For the record, I'm Ellie La Liberté. Well, this week we're tackling cases from gerrymandering to immigration. And to break it all down, we're joined by political scientist Howard Schweber. Thanks for joining us today.
Oh, thank you for having me.
Well, I want to get started with this gerrymandering case. I want you to take a look at the Wisconsin congressional districts now as they stand. So 6 of these 8 districts are currently held by Republicans. And the state Supreme Court ordered a pair of 3-judge panels to hear 2 lawsuits that argue the state's congressional maps must be redrawn. Those cases claim the maps unconstitutionally favor Republicans. Now, this comes ahead of the 2026 midterms and the president's real push here to try to preserve the slim majority they have in the House. And I want to start just by getting you to break down these 2 cases here for us.
So there are 2 theories. The most interesting one, and the one that frankly has the greatest likelihood of success, simply argues that these districts violate the Equal Protection Clause of the Wisconsin state constitution. And the reason that's so interesting is because of what happened last year. Last year, the state Supreme Court ruled that the districts that were in place for state elections violated that clause. Those districts that were ruled unconstitutional are the same ones that are now in place for congressional districts. But last year, the state Supreme Court declined to rule on that question. And there was a lot of speculation as to why. The assumption is it was basically political. They didn't want to get too far out ahead, over their skis, so to speak, early on in the tenure of a new majority. But the precedent there is very strong. If the first case was right about the districts for purposes of state elections, this case should also be right. Under the U.S. Constitution, states define districts, and state constitutions do come into play to limit the way those districts can be drawn. The second theory is much more novel and frankly has, I think, a much lesser chance of success. That's the claim that these districts unconstitutionally favor incumbents and that giving an advantage to incumbents is a violation of equal protection under the Constitution. There's a lot of reasons why that's a weak claim, but first and foremost, incumbents isn't a party. I mean, sometimes there's a Democratic incumbent, and sometimes there's a Republican incumbent. You know, this doesn't clearly benefit some group of voters or party or ideology in the state. It's just kind of a structural feature of the game. So I think that one is unlikely to succeed. But the first claim is really quite strong given the precedent from last year. And that's why the Supreme Court, I think, took up this case so quickly. There are no fact questions they have to resolve. There's no need for testimony. All of that was done last year. There was an enormous amount of analysis of facts in that case. Now it's just a straight legal question. Does this precedent apply?
And I want to talk a little bit about these panels, too. But first, I kind of want to talk about the fallout of this, too, because we saw conservative Justice Brian Hagedorn's response to this. He agreed with the liberal justices on this panels that the use of these panels were fitting, but disagreed with how the court assigned justices to this case. As you can see here, he wrote, quote, "I am not suggesting the judicial panels will fail to do its job with integrity and impartiality, but this approach is an odd choice in the face of a statute so clearly designed to deter litigants from selecting their preferred venue and judge." What do you think of the justice's criticism here?
I think he has a really good point. So to back up just a second, the reason there are these special 3-judge panels is because of a law that was passed about 15 years ago by a Republican legislature, for the record, that requires these appointment of special panels comprising judges from multiple different districts to hear cases of this kind. So as Hagedorn notes, there's nothing at all suspect about the procedure. What has potentially bad optics, let's put it that way, is that all of the judges chosen for these panels were either appointed by Evers or were supporters of current Justice Susan Crawford during her election. And that gives an impression that they were chosen for having liberal politics or perhaps pro-democratic politics. And I think Hagedorn is exactly right. There's no reason to believe they won't do their jobs honestly, but I think he has a strong point that a random selection would have had a better appearance, you know, helped shield against the perception or the vulnerability of an accusation of partisanship. And the really important point is none of this matters. And the reason none of this matters is no matter what these panels decide, these cases are going to go to the state Supreme Court. We all know that's where these cases are ending up. It will be the state Supreme Court that ultimately makes these decisions, including Justice Hagedorn. And so there's really no reason to appoint panels in this way that might give rise to controversy without unnecessary controversy or suspicion.
And let's talk a little bit about how rare using this panel is. Can you talk to me a little bit about that? You mentioned 15 years ago it became law.
Right.
Has it been used since then?
No. I believe this is the first time it's been used at all. It's extraordinary. It's as Justice Hagedorn pointed out, the reason for writing the law the way that it was is to avoid the possibility of venue shopping, forum shopping, where you go and try and find a judge who's sympathetic to your cause, bring the case there in order to get a favorable ruling. This is something that happens both federally and at the state level all over the country. If you think about federal judges issuing injunctions against the Trump administration or previously against the Biden administration, right? People always go to a friendly judge. So if you're a conservative, you go to the fifth, someone in Texas. If you're a liberal, you go to someone in Massachusetts. In order to avoid that in cases involving election law, this system was set up of these three-judge panels. Three-judge panels are not unique in general. That's how federal appellate courts work. The state of Wisconsin just borrowed that model for this particular purpose, but it is very unusual. It's in fact unique in Wisconsin state law, because these are such inherently political cases. And
I want to talk to you because it's unclear if even if these maps are to be redrawn, if they would be implemented by the 2026 midterms. Talk to me a little bit about that.
Probably not. And it's not because of anything formal. All of this takes time. It takes time to have these hearings. It takes time to issue rulings. It takes time to appeal. And the state Supreme Court will undoubtedly take time to reach a decision. So, truthfully, I think it is unlikely, even if the result is a slam dunk victory for the people challenging the current districts, which is not a guarantee by any means, but even if that were to occur, I think it's unlikely that new districts would be drawn in time for 2026. However, there's a very important election coming in 2028, and new districts could certainly, depending how this case turns out, be in place for that election, and of course, that will matter profoundly.
And I want to swing our attention now to some other news of the week. Also this week, we saw the state Supreme Court decide to take up a case the ACLU and Voices de la Frontera brought, arguing against sheriff offices' use of detainers. Right now, some sheriff's offices in Wisconsin hold immigrants arrested for crimes unrelated to their citizenship longer than the time they typically would. Now, that's in order to give ICE more time to pick them up. Advocates say those holds amounts to new arrests, and state law does not allow sheriff's offices to do that. Now, a date hasn't been scheduled yet for the arguments in this case, but why is it significant?
Well, it's significant for a couple of reasons. So immigration law is a complicated and technical area, and immigration enforcement actions proceed in ways that I think people would find shocking if they're not familiar with the system. In terms of the way people can be detained, deported, sometimes often without hearings, often on the basis of evidence that wouldn't be remotely enough for a criminal arrest, it's a whole different kind of parallel system that is much looser, for want of a better word, than the traditional system of criminal justice. Detainers are a piece of that. People whose immigration status is in question can be held in ways that ordinary citizens suspected of crimes cannot. And that's the clash here. State law doesn't allow for that kind of action. Federal law does. And so you have a situation of state police officials, voluntarily, I assume, cooperating with federal authorities to enforce immigration law. I suspect the ACLU's case is not a strong one. The reason is there's a very strong precedent that says the federal government cannot compel local sheriffs to enforce federal law, but that doesn't mean they can't voluntarily choose to do so. And if the issue boils down to just a flat-out conflict between state and federal law, you might have a question of what's called preemption. That is, that the federal law may simply trump, no pun intended, may trump the state law in this case. I'm not an expert in this very, very specific area, which is quite technical. But I think that this challenge is a reach.
And I want to talk to, speaking of immigration and federal powers, the judge in Milwaukee case, Hannah Dugan. Hannah Dugan is set to go to trial on December 15th. Now, she's a Milwaukee judge, you'll remember, who is alleged to help a man evade immigration enforcement in her courtroom. She was arrested back in April and indicted on federal charges. Now, her defense has made the case that she has the ability to oversee her courtroom as she sees fit. And this case has gained a lot of national attention. What are the ramifications of this trial?
It's a little hard to say. So 4 weeks ago, there was the initial charge, and then evidence has sort of been trickling out, and some new documents were filed just yesterday in the case. The most damning piece of evidence, I think, is a statement attributed to the judge, which she says, "I'm in the doghouse because I helped that guy find this hallway." The case turns on the idea that she helped an illegal immigrant exit the courtroom in a secret way, a non-public hallway, in order to avoid ICE agents. That allowed him to reach the outside. He was then detained outside. The federal agents are claiming that, yes, she has the authority to manage her courtroom, but not to the point where it interferes with law enforcement. And as a general proposition, that's certainly true. The authority to manage a courtroom does not extend to interfering with the enforcement of the law. On the specific facts of the case, there is, for example, an audio tape that has not been released that contains the judge's statements from the bench. So there are things we don't know. If we assume, however, that the prosecution is able to prove each and everything that it alleges, that the story is exactly the way that they tell it, it looks like she's in trouble, that she went too far. So the ramifications are important. We've seen a pattern over the last 6 months of immigration enforcement officers showing up at courts. And the reason that matters so much is you have people trying to follow the rules, people showing up for scheduled hearings, people showing up sometimes to complete their applications for citizenship or to complete their applications for a green card and being arrested at the courthouse when they're trying to do what they were told to do. And the problem with that is if you make people fear that going to the court will get them arrested and deported, you lose cooperation of witnesses in criminal cases. You lose the ability to encourage people to play by the immigration rules that we want them all to play by. You undercut the reliability and the trustworthiness of the system itself. And that can have all kinds of harmful ripple effects on the operation of courts. And so in one sense, this isn't just about the management of a courtroom. This is about the ability of the judiciary to manage the courts and the ability of federal law enforcement to interfere with that management and undermine the maintenance of order in the courts. And so that's the bigger issue. That's the larger picture. The specific case is going to turn on whether this judge showed poor judgment at a particular moment. And we'll have to wait and see, of course, what the facts show. But the prosecution has a fairly strong case. It looks, based on what they have filed, it looks as though they have a fairly strong case against her.
Well, Howard Schweber, thank you for joining us this morning.
My pleasure. Thank you for having me.
Liberal Supreme Court Justice Janet Protasiewicz will not recuse herself from former Justice Michael Gableman's disciplinary case. Gableman led an investigation into President Trump's loss in Wisconsin back in 2020. The Office of Law Regulation accused him of misconduct during that probe. In April, he agreed to surrender his law license to settle multiple violations. Now, in her decision, Protasiewicz wrote, Gableman has failed to carry his burden of proving that I must recuse myself from this attorney disciplinary proceeding. Therefore, I deny his motion for my recusal. This also comes after liberal Justice Susan Crawford also denied Gableman's request for her recusal back in October. The hundreds of thousands of Wisconsinites who rely on federal food assistance are once again in uncertain territory. On Tuesday, the president said he would withhold SNAP from most Democratic-led states unless they provided information about who relies on the program. The administration specifically wants the names and immigration status of recipients. The announcement comes as people are still dealing with delays in federal food assistance after a battle between states and the White House over that federal food assistance during the government shutdown. And next on For the Record, after months of speculation, a new name in the race for governor shakes up the Democratic primary. Why Mandela Barnes says he's running when we come back.